Thank you for viewing this YouTube archive of a Conscious Consumer Network broadcast. Please feel free to share it far and wide. Check out our weekly broadcast guide for weekly updates on scheduled broadcasts. Help keep us on the air by contributing to our network support fund. You can follow us on Facebook and Twitter, or get in touch via email. We thank you for supporting free and independent media.
All right, thank you. Hi, ladies and gentlemen. This is the first show for Private Attorney General. My name is Rod Klass. I live here in the United States in North Carolina. What we're going to get into here for the next 2 hours is going to be what we have here in the United States, the outer limits. We control the volume, we control what you see, we control everything. And this is what we are dealing with here in the United States with our court system, with the Bar Association, is they're trying to control everything. Throughout the years that I've been doing this, and this goes back to 2001, here in the United States, whenever I got pulled over for a traffic stop, I was under the impression, like so many of you, if you were honest, you told the truth, and you went before a judge, you would get a fair hearing. Well, I got a very rude awakening. When we went before them, they wasn't interested in the truth. They wasn't interested on what is right. All they wanted to do was collect court costs and fines and federal funding, which we found out later on. This is a very significant issue. This is what got me started on this. The gentleman that taught me back in 2001 taught me 3 things. And he taught me well. And it is something worth understanding. It is something worth going after. And that is, number 1, when you're dealing with the courts, when you're dealing with any public office, you have to know their job description. What is their job? What are their duties? What are their regulations? How are they supposed to function? All right, this goes back here in the United States. If you work for Ford Motor Company, GE, or any other company, and I imagine it's the same way in your country, that if you work for a corporation, when you are hired in, you got a set of rules. You got regulations. They hand you a little manual and says, okay, this is the policy of this company. We expect you to comply with the policy of this company. This is the same thing with what we have in our government, with our court system. They have policies, they have rules. So part of what we are trying to get across to what we're trying to teach for the next roughly 2 hours is I'm going to break some stuff down for you that if you are in a court battle, and I've been in quite a few of them since 2001, but what I've learned from this old gentleman, if you know their job, you know their rules, and know their language, them 3 things is the most powerful thing that you can walk in with. And what does it mean, know their job? All right, it's like a brain surgeon, automobile mechanic. You have to understand what their job is, how it functions. What's the job of the prosecutor? What's the job of the judge? What's the job of the lawyer that's supposed to be in here representing you fairly? That's supposed to be in here working for you because these people all took an oath to the Constitution. And from what research that I've done, every country out here has a Constitution. In that Constitution, it tells you what they can do, what they cannot do. What is the function of legislation? What is the function of the president? What is the function of the judicial branch? What is their job description? What is their limitations? These are things that you need to come back in and understand. But there's more to it than just that. This is just a foundation. This is just a starting place to come back in and look at. The next issue is their rules. Well, what is their rules? Their rules consist, if you deal with the court, local rules for that court. What we found here in the United States, each one of these courts has its own separate rules, has its own separate policies. There's no consistency. There is no straight across the board. Every one of them is foreign to one another. And I want you to remember that word, foreign to one another. Because if these courts were operating under one system, then it wouldn't matter whether you were in Maine or Florida, North Carolina, whether you was in Ohio, whether you was in Alabama, California, Oregon, Montana. One book, one rule book, you should be able to walk into any court in this country and come in and go head to head with these people. But that ain't how it works here. Every one of these courts, local courts, has its own local rules. So you have to get into the local rule book. What are the local rules? You have to get into what is known as the civil rules of procedure. You have to get into what is known as criminal rules of procedure. You got to get into what is known as the rules of evidence. These are the four foundational books. They're rules. Local rules, civil rules, federal rules, criminal procedure, and rules of evidence. Now, here in the United States, the criminal rules and the civil rules for the state level, the federal level, are pretty much in line with one another. They pretty much, you can go in and read and show that Rule 4 of the civil rules and Rule 4 of the state, the federal, are the same. Get into the rules of evidence for the federal and the state, the rules, the numbers pretty much match. Same thing with criminal rules, pretty much match. There may be a little bit of verbiage difference, but the concept is still there. And this is one of the biggest things I'm going to tell you people right now. You have to be able to comprehend. That's number one. You have to be able to associate. That's number two. Whenever you are looking at these rules, you're looking at the books, you have to be able to comprehend what you read and associate with what you are reading. You have to be able to sit down and say, okay, there's a little bit of difference here to what is here, but they are saying the same thing. There may be a little more verbiage, but what they're saying is under federal civil rules, number 2, there is but one course of action, civil. That's it. Under the state, it may have a little more verbiage, but it's still coming out saying there is one course of action, civil. So you have to learn how to associate, and you have to learn how to be able to comprehend. And that comprehension and that association is very important throughout this whole thing that we're doing. Very important. We get into, and I've had several issues here with some people in the state of North Carolina. It's called Department of Motor Vehicle. Well, in Ohio, it's called the Bureau of Motor Vehicle. Rod, you said department. We don't have a department. We have a bureau. Ladies and gentlemen, comprehend, associate. Just because we have a department here and you have a bureau, the Department of Transportation, Department of Motor Vehicle issues you your driver's license. In Ohio, the Bureau of Motor Vehicle issues you your driver's license. We have a department, we have a bureau. The point is that no matter which name you use, they give you a driver's license to drive. And you have to be able to associate, you have to be able to comprehend. We don't have time to try to be a mind reader of, okay, how do I sit here and what word do I use? I need to read your mind here so I can understand how to get this across to you. But the problem of it is, I got 3,000 other people out here. So now I have to sit down and individually try to read your mind 3,000 times, or 5,000, or 10,000, or ladies and gentlemen, it's up to you on your side to comprehend. It's up to you on your side to associate. It's up to me to try to read your mind to get this across to you. This is one of the things with what we are doing here in the United States. I have fought the system by knowing their rules, knowing their job, and I'm going to come down to their language. All right, what's the big deal on language? Quite a bit. Whenever they write the books, now people need to understand something. Here in the United States, and I'm assuming that it is the same across the globe, our legislation in this country, get what is known as a bill. Somebody wants to pass a law, so they make a bill. Bill goes before legislation, and if it gets passed, it becomes an act of Congress. Therefore, it is now enacted. That now goes into our statutes at large. That is Congress' intent of how that law is to be interpreted. This is where the definitions and the wording should come in. This is very significant because here in the United States, we have what is known as Westlaw Publishing Company. Westlaw now takes the statutes at large, and they now convert them into the United States Code. The problem of it is they're changing the verbiage, they're changing the intent, they're changing the meaning of what is being said. Through my research from 2001 up to here we are in December 2015, going to be rolling over into 2016 here in a few days. Through our research, going through the statutes at large, we have found where the United States codes were never passed. They were never legitimate. Back in December 1925, on December 7th, supposedly, under HB 10,000, Congress sat down and got the statutes at large, and they created and passed what was known as the United States Codes. There's too many errors in it. And our Senate said, no way. No way, Jose. Not going to happen. You get too many errors, and we're not going to pass this. Well, supposedly this was done on December 7th, 1925. Now, this date is very significant because when you get back into the statutes at large in our country, and that's what I want you to do with you need to go back and do some research. On March 4th, 1925, under volume 43, that's where that volume stopped. March 4th. Logic tells you, okay, this was stopped on March 4th. So volume 43 and a half or 44 would have to pick up on March 5th, 1925. That's not what happened. That's not what happened at all. It flat out stopped on March 4th, 1925. Flat out stopped. Volume 44 picked up on December 16th, 1925. March 4th, December 16th. What happened to all the months and days between March 4th and December 16th? Supposedly, on December 7th, 1925, the United States Code was passed into law. They never were. We got the congressional records go back and prove this. Ladies and gentlemen, this is what is significant about what we're trying to teach. Know their rules. Know their rules. Know their job. Know their requirements of what is going on here. What we discovered here in the United States on March, here in 1935, under the Federal Register, in 1935, under the Industrial Reclassification Act of 1935, the Recovery Act, Congress allowed our president and an administrative committee to go in, codify the statutes at large for administrative purposes to be used against the administration, not John Q. Public. Ladies and gentlemen, this is why I tell you, we have to know what their job is. You have to know their rules. You have to know that language. Now, where does the language come into this? As you read, most of your statutes say no person. No person shall commit a fraud. No person shall commit a crime. No person shall do this. No person shall do that. That word person, you assume it's you. We've been taught to believe that. We've been taught that this is how it works. This is how we've been taught. The language of the court system is different than it is out here in the street. This is one of the things that I have been able to prove in court cases, is that we have walked in and made issues on this. We have walked in and we have made dramatic changes in this. Because when you can walk in, go head to head with the prosecutor, and the judge tells that prosecutor, sit down, shut up. When they come back and they do this with you, then you have a pretty good understanding of what is going on and how it is going on. Whenever you can sit back and you can show the judge, excuse me, Your Honor, I would like to point out to you, under Title V of our United States Code, Title V, under 552A, it says the word person and the word individual. I want to show you that that word person and individual, it only reflects back onto those that are citizens of the United States or a foreigner applying for permanent residency. Now, in this country, a citizen of the United States falls under what is known as our 14th Amendment. Our 14th Amendment, if you read it, throughout history, it has tried to tell you that that 14th Amendment freed the slaves in this country, gave them rights. Yeah, 14th Amendment gave the slaves rights. That ain't what it says at all. You go down and read that 14th Amendment of the Constitution. You read Section 2(3), and it talks about public offices. It talks about the president. It talks about the vice president. It talks about the Congress. It talks about legislators. It talks about judicial officers, federal and state. Now, wait a minute. 14th Amendment. My God, that citizen of the United States is public offices. That has nothing to do with John Q. Public. It all deals with public office. Those, because the 14th Amendment tells you how they are to hold that public office and what type of good standing they're supposed to hold it in. So how does that have anything to do with freeing the slaves in this country? Doesn't. This is part of the fraud. You got to go back in and comprehend what you're reading. You got to go back in and associate what you're reading. Because when you read that 14th Amendment and it sits there and says president, vice president, the judicial officers, legislators, civil service, military, it doesn't say one thing about freeing slaves. Where's the association here with what this is saying about slaves? It has nothing to do with slaves. It has everything to do with public office. This is what we're finding out within our Constitution and the amendments. And I want to let you people know that there is a distinct difference in this country between the Constitution, Bill of Rights, and the amendments. These are three separate issues. The Constitution it deals with public offices. It deals with legislators, presidency, the court system, how laws are to be passed under Article 4. Well, Article 4 Article 4 is into what is known as full faith and credit from one state to the next. What does that mean, full faith and credit? Well, what it means is if I have a right in my state and I go to the next state, they have to give me that same right. Also, Article 4 gets into, it talks about how they can create a state within a state. Don't say one thing about creating a company or a corporation. Doesn't say one thing that you can take two states and I'm going to make a city. That ain't what it says. It says you have to make a state. And they created DC. Well, that's a federal zone. Excuse me. It does not say that. Article 5 of our Constitution gets into how bills are to be voted on. 2/3 of the House, 3/4 of the state. 3/4 of your state has to agree with any amendments, any changes, any legislation. They're not doing that here. But that is part of the requirement. Article 6 gets into Supremacy Clause, the main law of the land, all treaties, all the laws, Constitution. It also gets into how they have to have an oath in order to hold that position. They have to swear to uphold in order to take that position. Article 7 goes into where it allows Congress to make changes and for things to be nullified. Then you have the Bill of Rights, 1 through 10. The original Bill of Rights were set up as articles, 1 through 10. But they sort of switched them over and named them amendments, 1 through 10. But that's our Bill of Rights. Then the amendments come in, 11 up through. Now those are amendments. So these are three separate documents, but not one. They may be in one book, but these are three separate documents. They are totally separated. They do try to combine them. This is part, again, come back in, understand what they're doing. Don't allow them to sit here and run you in. Well, we're going to protect your constitutional rights. No. Constitution applies to you, except for Article 4, where you got to give me full faith and credit, and you have to give me the same right in this state as what I have in my state. This is what Article 4 is good for. 14th Amendment of our Constitution, you got to give me equal protection. You can't deprive me of my rights whenever I have my rights in my state. You got to give me the same right in your state. Again, they're not doing this. This is a very important issue that's coming off here. Very important. Understand, comprehend, associate what's being said here. It takes time to learn this stuff. Like I said, I really got heavy into this in 2001. I've been doing a lot longer than that, but I got heavy into this in 2001 when they started dragging my butt into court. And I started fighting them. Like I said, the gentleman that taught me know their rules, know their language, know their job. And I'm going to throw that fourth one in here. No legislative intent between what legislators write and what Westlaw Publishing writes. Because they modify and they change. And the moment they change, the verbiage is no longer law, it's concept, it's theory, it's color. It's not genuine law unless you challenge it. And that's part of what we're trying to do here. We're trying to teach people how to challenge the system, how to come back in and stand your ground, how to come back in and argue. You're getting into what is a chess game. It is move, counter move. You have to have more answers than they get questions. Your knowledge level has to increase whenever you are walking into court. These symbols behind me, this one on this side, Private Attorney General, comes in. My authority is under Title 42, 1983, and 1988. The penalty section falls under Title 10 and Title 18. Title 10 in this country is military. Why military? We're going to get into that. This side is the bounty hunter side. This side comes under the 14th Amendment. This side comes under Section 4. That 14th Amendment deals with their public office on how they are to behave. Now, am I classified as a bail bondsman? No, I'm not. I am what is known as a constitutional bounty hunter. What's the difference? The difference is this. If in this country, if you go up before a court and you pay a bail or bond and you don't show up, the bail bondsman hires a bounty hunter to go out and drag you in. Why? What did you do to have him drag you in? You breached your bond. Think about what we're saying here. You breached your bond. Therefore, that bounty hunter has a right, because you had a bond, doesn't have a warrant. They kick your door in and drag you out because you swore that you would uphold, you would bring in You would sit here and honor that contract, and you didn't, so they could drag you in. As a constitutional bounty hunter, we are trying to push that same status. We haven't got that far yet because right now we need more people educated. We need people adversed in this. We need people aware of what's going on. We need people that's willing to stand up. Part being a PhD is being able to bring claims against these public officials. In this, what in this country, because of the bankruptcy of 1933, and there was like some 43 other countries that went down at that same time, 33, under bankruptcy. Under the bankruptcy, what we're dealing with, this all ties in. This all ties in. Is there's no money. These people swore an oath to uphold the Constitution. These people swore an oath to abide by the bankruptcy of 1933. This is part of the reason why when the USC codes were passed through the Federal Register and through the Industrial Recovery Act, is they can only apply them to administrators, to public offices. They could never apply them to John Q. Public. Because in 33, they stripped the United States, they stripped the people of its gold. We were given Federal Reserve notes, FRNs, a little green sheet piece of paper that's got a 1, 5, 10, 20, 50, 100. Got Federal Reserve note written across the top. That's not money. These court systems, bar association, these people are aware of this. They have an understanding of this. This is what we're getting into. This is why the private attorney general side, bounty hunter side, is why we are starting to introduce this to the people of the United States at a bigger level. Granted, there are other people out here that are doing it, have been doing it for quite a few years. But they're missing pieces. They're missing the main parts of going after them. Because they're not understanding their rules, not understanding their language, they're not understanding their job descriptions. And they sure are not understanding congressional intent of how the law is written compared to that of Westlaw Publishing in this country. There is a significance, there is a huge, huge difference of what we are getting into and what we are trying to propose here with what we're doing. We are trying to get people to understand that these agencies don't have the jurisdiction to drag us in without an injured party. There has to be an injured party. This goes back into understanding the language, understanding their rules, understanding their job description. In this country, prior to 1933, we had what was known as common law. And common law pretty much was that you had to have an injured party. The two injured parties came in and they went head to head. You may have had lawyers, but it was still two injured parties. In today's society, since 1933, 1940s, what has happened here is that we are no longer bringing in an injured party. We're bringing in the state of. The state of falls back under that 1933 bankruptcy. That state of falls back under military law. This also falls back in where the problem comes in with criminal jurisdiction. Throughout the research that has been done, that I have done, other people have done, going back in and looking at criminal jurisdiction, criminal rules of procedure, looking at this, understanding this, is creating a problem here. And why? Because Congress never gave the court legislative jurisdiction criminally, not in the rules. Going back in and looking on the state level, looking up criminal rules procedure. As you look through the rule book, it has a section that has jurisdiction. And right in that section, it says reserved for future codification. Reserved. Wait a minute, stop, whoa, back up. Let's stop and think about this for a minute. Legislation, when they wrote up the criminal rules of procedure, gave them venue, gave them all kinds of wonderful things. As you get down and read this sucker, and that tell you what, it's so impressive. I might put a lot of time in this. But when it comes down for the court to have jurisdiction, it says reserved. This spot is reserved for future codification. For future codification. Well, it's for future codification. That means the court don't have jurisdiction. This is why, going through their rules, this is part of knowing their job. Excuse me, Your Honor. We have an issue here because in order for you to function, for you to fulfill your job description of a judge running this court, under your job description, don't you have to have jurisdiction? Oh, yeah, we have to have jurisdiction. I have jurisdiction. You do. Well, then maybe you can sit here and explain under criminal rules procedure why it says here it's been reserved for future codification and the court has never been given jurisdiction criminally. Maybe you can explain this because legislation hasn't given it to you. It stops them cold in their tracks. Because you got the book in your hand and you can sit here and say, you want to see it? Here it is. In order for you to move, you had to have. Prosecution never gave it. Prosecution can't give it because legislation never gave it to you. Therefore, you have no criminal jurisdiction. Everything that we're doing here, ladies and gentlemen, everything that we are talking about, everything that we're trying to get across to you, of knowing their rules, knowing their job, knowing their language, and understanding congressional intent, what we are attempting to do with you is this. We are switching roles from being a defendant to being a prosecutor. We are switching the roles from being a defendant to where we are now the plaintiff in this court case. Well, Rod, how are you becoming the plaintiff? Because by knowing their rules, knowing their language, knowing their job, and knowing congressional intent, you now can walk in and say, the moment the case starts, I object. One, you don't have a corpus delicti. You don't have an injured party. You can't hold criminal jurisdiction in here because legislation never gave it to you. Here's your rules. If you are going to claim some type of criminal jurisdiction under the 1933 bankruptcy, then you're claiming it under military law. And in this country, it's Title 50. So Chapter 3. Chapter 3 is alien enemy. Section 23, jurisdiction of the courts and judges shall have civil and criminal jurisdiction over, and it comes down to over alien enemy residents. Now think about what it's sitting here saying. Alien enemy residents. You're born here. You're not a resident, and you sure are not alien. You are sitting down and you are exposing everything that they are doing wrong. You are laying it out and you are showing them right off the bat, before they even get to your case. You are walking in and you are showing them right off the bat that they are wrong. You're coming in and you are addressing the fact that under Civil Rules Procedure, Rule 3, that there had to be a complaint. There had to be an affidavit. There had to be a summons or a warrant. Criminal Rules Procedure 2, 3, 4, and 5 are very explicit. There has to be a complaint. There has to be an affidavit. There has to be either a summons or a warrant issued. Not an option, not a choice. It is a requirement as part of their job description. Before they can do anything, they have to maintain and they have to produce complaint and an affidavit. Part of their rules. So before we can talk about anything that I've done, let's talk about what your side did not do right. You are switching the roles, ladies and gentlemen. You are switching the roles from being a defendant to being a plaintiff. You are now coming in technically as a private attorney general. You're coming in as a prosecutor. That's what a private attorney general here is in the United States. The United States, from what is the only country that I have done a little bit of research on that shows that it was actually a congressional record, a congressional commencement in 1866, giving the people of the United States the ability to sue the system. It takes time. It takes knowledge. It takes you the ability to understand what you're getting into. It takes you to be able to comprehend, and you also need to understand, do I really want to do this? What is the risk that's involved? What's the risk? Because when you start going after the system for corruption, there's retaliation on their side of events. And that's something that you need to come back in and understand. There is retaliation. They could come after you. But ladies and gentlemen, your freedom is at stake here. Your rights are at stake here. What I have done here in the United States, and because this is international, because we are in a lot of countries, we're in Australia, Netherlands, Germany, France, England, United States, Canada, because we are talking internationally. You need to go back and research. You need to go back in and see what your legislation has wrote up. I know just briefly going through Australia, I got into the southern province of Australia. I got into the criminal rules of procedure. As I was going through the criminal rules of procedure, I found sections that says revoked. They revoked them. And that's in a separate book. It isn't in the one main book, that's a separate book. Australia also has what is, I discovered, has your youth court. It has your magistrate, your district, has a fast track court. These are all different rules. That's why I'm sitting there saying you need to get in and you need to read your rules. You need to understand what you're in, where you're at. This stuff takes time. Don't be in a hurry. It's taken me a long time for me to build my competence up enough for me to go after these two. I already hold the position. Congress gave it to us. That's one thing about the United States. Congress gave the people the ability to be private attorney generals. Congress gave the people the ability to be bounty hunters if we knew how to use it. Taken me a long time. Here in the United States, I run a program, and we're simulcasting right now on TalkShoe.com. In my archives, under TalkShoe, that's S-H-O-E, not show, shoe, like what you put on your foot is shoe. TalkShoe.com. My ID number is 48361. Or look up Rod Class on the internet. I'm all over the internet. And you'll come across my program. And I have over 960 plus archives of us talking where I got Harvey, he's a commentator with me, Carl Weston. He was on here with me. Marie was on with me. We had Jeanette Triplett that was on. She's a fabulous researcher. She's one of the best researchers that I have. This is a nationwide setup. I set up AIB Radio. There are so many, I want to say, patriot movements out here. A lot of these people are correct, but they're missing pieces. They're missing important pieces. There's so many of these people have walked into court and they told the judge that I am not a person. Were they lying? No. Could they sit here and explain it? No. I walked in my court case in DC, and I flat out told the federal judge, I am not a person under your statutory law. Excuse me, ladies and gentlemen. I'm not a person under your statutory law. She said, well, what do you mean? I said, like I told you people heard earlier, under Title 552A, and where a person is a citizen of the United States, or an immigrant applying for permanent residency. I'm neither one of these. There's your legislative law that says what a person is. Show me how I qualify. It created a problem because I was able to stop her in her tracks. Granted, she had me go down for a psychological evaluation. But going down and seeing the psychiatrist down there, and his colleagues down there, talking with him for about an hour and a half, they decided they didn't want to play with me no more. And the reason why is because in this country, ignorance in this of the law is no excuse. You walk into a court, there's an issue. Well, Your Honor, I didn't know. Ignorance is no excuse. You're supposed to know the law. And that's what we're coming back in. We know the law. We know their rules. We know their language. We know how we're supposed to be functioning. And they're not doing it. When you walk into that courtroom, you're walking into that courtroom not as a defendant. You're walking into that courtroom as a private attorney general. You're walking into that courtroom as a prosecutor. You're walking into that courtroom as a plaintiff, no longer a defendant. Like I told people here in this country, I do not know how to defend myself. I don't know the first thing on defending myself. But I can walk you through every one of their criminal activities. I can walk you through every one of their rule violations. I can walk you through what they didn't do right. That's what's important. That's what's important. Read your books. The issue that I had here in North Carolina administratively, I got picked up for a couple of traffic stops. As soon as I got stopped, that's what I tell people. You get stopped. The moment you get home, you start paperwork. You file it into your administrative court. You file it into your local court, and you have the venue changed. Because when you get a court date for that administrative court, that overrides that other court. Because you've changed the venue. Because you're dealing with an agency now. You are sitting down. And you are now exposing You are now sitting down and going after them for procedural violations. That police officer stops you, pulls you over. You don't get into a confrontation with them out on the street. You do it with paperwork in the courtroom. But see, what you also have here is this. Let's sit here and say, for example, that you get stopped, file paperwork tomorrow. You got a court date that's 90 days off, 60 days off. According to the local rules, that prosecutor has to answer you within 14 days, or 20 days, 30 days at the max. Now, think about what I'm sitting here telling you. You get stopped today. You get paperwork filed tomorrow. You got to be in court in 60 to 90 days. It's 3 months. That's 3 months. Local rules sit here and says that prosecutor has to answer you within 14 days, 20 days, or 30 days. He hasn't answered you because he doesn't have to. Yes, he does. Because if they charged you, you have the right to file paperwork in that day, and that prosecutor has to answer that paperwork before that court even starts. People aren't doing this. People aren't aware. This is what we're teaching here in the United States. This is what we're trying to get people educated on here in the United States. You people internationally, you have to go back in and you have to check what your local rules are. You have to check what the guidelines are. Water time. You got to check. This is part of what we're trying to get people to understand. This is what we're trying to get people to be aware of. Like I said, today's program, ladies and gentlemen, is just to familiarize yourself with what we're doing here, what we're getting into, what we're talking about. Don't want you to jump into anything right now until you get better educated. I have watched too many people, and I use this as an example. They want to jump into the middle of this thing. And that's the key word, jump into the middle. I would like to see you people to bake a pie or bake a cake in the middle. You only have half the recipe, the last half. You don't have the first half, and you're wanting to jump into this thing. You can't bake a cake, you can't bake a pie without first getting the mix, getting the bowl, and putting the contents into the bowl. That's the beginning. This is what so many people are missing, the beginning. You're trying to fight this on their level of a halfway in the middle. They're dragging you in halfway into this thing. You need to put a stop. Says, well, wait a minute. Let's go back to the apple. Let's go back to the foundation. According to your rules, under civil rules and criminal rules, according to your rules, your police officer had to have a complaint and an affidavit, either summons or warrant. Up front. In this country, he had to Mirandize me before he even talked to me. What that means is this in this country, is they don't have the right to search, question you, and then sit down and say, okay, now I'm going to place you under arrest. Anything you say can will be used against you in a court of law. If you cannot afford an attorney, one will be appointed to you. Do you understand these rights as I have sit here and told you? But yes, I do. So that means that everything that we just talked about for the last 3 hours and everything you went through my vehicle for, you can't use it now, right? That's what this means. If they're going to search, this is their job description. These are their rules. This is their language. Their rules, their job, their language says they have to Mirandize you before they talk to you. They have to meet certain qualifications before they stop you out on the street. And they're not doing it because the court system and your lawyer and the prosecutor is not addressing any of this because there's money to be made. There is railroading to be done here. This is what being a private attorney general is about, is knowing your rules, knowing how to defend, knowing how to sit down and say, whoa, wait a minute, you violated your rules. Your case has to be dismissed. Supreme Court has made these rulings. Rules of evidence. Well, Mr. Class, you can't bring that. Yeah, under rules of evidence. It says under Rule 12 that I can rebut. I have to rebut. I have to rebut anything that is said by the prosecution under Criminal Rule 12 and under Rules of Evidence. The Rules of Evidence 402, 501. The Constitution is admissible. Federal statutes are admissible. These rules are admissible. Supreme Court decisions are admissible. Under Criminal Rule 12, it says I have to rebut. And you can't withhold information because it can afford me an appeal and you cannot deny me an appeal. Therefore, I have the right to come back and show every error, every screw up that your police officer did or your prosecutor did. Education, ladies and gentlemen. Education, knowledge, understanding. This would be a good time to have a commercial. And what do I mean by having a commercial? In this country, we see little puppy dogs with a little sad eyes, and they're all get their head down between their paws, and they just look up at you and just got these sad little puppy eyes, and they're just so neglected, and they're in a cage, and they're in all this stuff. And that's the same thing with what they show here about little people over in Africa that for 19 cents a day, you can feed this child. Okay. Suppose we sit back and address it this here way. How many of you people have went to court and you found out that your lawyer withheld vital information, such as you were not Mirandized. Right. That's enough to have your case dismissed. How many of you have walked into court and under the criminal rules, you have to file a rebuttal in your prosecution? Your public defender or your lawyer does not file one stitch of paperwork in to rebut the charges. What about you walking in here and here in the United States, there's a big issue on the word firearm. That's what my DC case was about, firearms. Whenever I confronted the public defender on this, and we brought up the congressional enactment of the National Firearms Act of 1934, and it defined a firearm in this country as a shotgun that's been modified to a barrel less than 18 inches, overall length less than 26. A rifle that's been modified to a barrel length of 16 inches, overall length less than 26. A fully automatic machine gun and a silencer. This is what is registered and classified as a firearm. To substantiate this under IRS and ATF, in order to obtain a firearm, you have to be able to pay a tax on it of $200 a year. Not for a rifle, not for a pistol, for a firearm. ATF defines what that firearm is. That's what I sit here and told you. What would you do when you walk in and your lawyer refuses to address the legal terminology of your charges? What would you do? How many of you have been railroaded because your attorney that you were hired or were appointed to you did not sit here and make the issue? Your Honor, I would like to make the issue here before this court that the state of cannot be an injured party. I want this case dismissed in my client's behalf because there is no injured party in here, and the state of cannot be injured. Because the state of is fictitious. Does your lawyer tell you this? Does your lawyer ever discuss this with you? What about driver's license? Your Honor, I would like to object to this proceedings. My client required to have a driver's license because under federal regulations, under United States Code Title 49, USC Code Title 49, CFR, I would like to reflect back that because they are USC codes and codes of federal regulations, these are administrative codes. And as my client is not part of the administration and he is not in commerce and he does not work for the federal government or the state or any political subdivision as it states in Title 49, USC Code and CFR, is that I would ask this case to be dismissed based on the police officer made a mistake. He erred. Have you ever heard your attorney ever say that? Your Honor, we're in here today for a foreclosure, and I would like to remind this court on behalf of my client is that under the banking regulations, under Title 12, 95, 95A, 95B, is that when my client here signed the mortgage note, and he's not saying he didn't sign it, he's saying he did sign it. But when he signed it, and he signed that promissory note, is that the court was required to take this down to the comptroller of currency or to the alien custodian, property custodian, as defined in Trading with the Enemy Act under Section 17. Therefore, the bank was supposed to have discharged this man's debt. So we're not in here under bankruptcy on his behalf, but we are in here because the bank did not do their job pursuant to the bankruptcy of 1933. Has your attorney ever said anything like this to you? Has your attorney ever put up a defense? Your Honor, I would like to remind this court that my client here, since the bankruptcy of 1933, and the fact that the government came in and relieved my client of any means of being able to pay in gold, and whereas under the Social Security Act of 1935, my client here had a $1.8 million value on him, which is $1 million each fiscal year. And Your Honor, you're asking him to pay fines. Well, Your Honor, pursuant to the federal regulations in this, under Title 18, Section 8, obligation of the United States, I would like to remind this court that my client has no way of paying any mortgages, has no means of being able to pay any type of child support, can't pay taxes, because it is strictly forbidden under Title 18, Section 8, that anything that he could possibly use is not his to use, but is an obligation of the United States. And therefore, I would move this court to dismiss the charges. Have you ever heard an attorney ever sit here and say that for you? Ladies and gentlemen, this is what we're talking about. This is what we're missing. We are not educated. We are not knowledgeable. We have been kept dumbed down and ignorant of all of this. This program that we're doing here is to help get you to start being aware of the fraud that has been perpetrated upon you. Get you aware of the railroading that the system has done to you, not only here in the United States, but worldwide. That's why I was asked to come on and start a show here with you guys, to start educating the entire world on what's going on. It isn't the people of the United States that's the problem. People in the United States, in a lot of ways, are just as ignorant. There are a handful of us that are knowledgeable. There is a handful of us that is aware of what is going on. There's a handful of us that is trying to educate and bring knowledge out to the people. And because of the success that we have had here in the United States, we was asked to bring this out internationally. Every country is different, but the foundations of what we're teaching here in the United States goes worldwide. What we're teaching here in the United States, going back and learning their rules, learning their language, knowing their job, and knowing congressional intent, ladies and gentlemen, is universal, regardless of what country you're in. You have proper procedures to go through. You have proper channels to go through. You have to find them in your statutes. What we have discovered here in the United States under a tort claim is that whenever you go after a public official, you have to first go to them and their agency. And who controls that agency? Here in the United States, if we're dealing with a police officer, city police officer, you have the mayor, the city council, you get the city law director, of course you get the chief of police. But here we contact the governor and the attorney general. Why? Federal funding is involved. Anytime federal funding is involved, you got to notify the governor and attorney general. Well, how do you know that there's federal funding involved? Through years of research, the bulletproof vest that these police officers wear out here went through United States legislation for federal grant money to be given to them to afford bulletproof vests. The camera in their cruiser goes through federal funding through United States Congress in order for them to obtain, for them to have a camera in their cruiser. The Highway Safety Act in this country is a federally funded program. Your political subdivision gets 40%. The state gets 60% federal funding. The driver's license itself is a federally funded program orchestrated by the Secretary of Transportation that has to approve the state's compliance in order to obtain the ability to hand you a driver's license. Funding. Know their job, know their rules, know their language, understand legislative intent. Everything that we're going through, everything that we're walking through, everything that we're sitting here explaining here today always goes back in to language, rules, job description, congressional intent. Everything that we're talking about. Associate. Learn how to associate. Comprehend. There isn't anything at all that you cannot come up with that if you will apply this and do your research, that it will not work on. It works on everything on their side of the fence. Now, does it work on you and I? That's where people are making a mistake. It does not work on you and I. You and I are not in that ballpark. What we are teaching is when the system comes after you, when the system is trying to drag you in, is where this stuff applies, is where this stuff works. It's education and knowledge on our side. It takes time. I will tell the people here, I'll tell you the same. Rod, I got to be in court in 30 seconds. My comment to you is pretty fine. You don't have time to learn. Rod, I got to be in court tomorrow, pay the fine. You don't have time to learn. But what I will tell you is this, pay the fine because there is no statute of limitation on fraud. And because this is a constitutional violation and a federal funding violation, you can always take them back in and charge them in the administrative court. Bring an administrative claim against them. Set them up for a lawsuit. That, ladies and gentlemen, that is what this whole program is about. Is setting them up to bring a lawsuit against them for accountability. That's why we're in here talking. That's what this is about. It's about education. It's about accountability. It's about how to hold them accountable. What do you look for? What do you need? How do you start? I have here in North Carolina being pulled over by the local police department. I got picked up on a Thursday evening about 3:15. 4:30, I started paperwork. 9 o'clock the next morning, I already had the court served. And I had the administrative court document filed. Be sent to Raleigh for an administrative hearing. I got a hearing date for the administrative hearing. I took it in to the prosecution. And because my administrative hearing superseded theirs, they had to shut their case down because I brought them in administratively because this was an administrative issue because I'm dealing with an agency, not a private individual that was injured. I'm dealing with an agency. Therefore, this has to be administrative. And when I have checked in Australia, you do have what is known as the Administrative Procedure Act. I've checked several other countries. You do have Administrative Procedure Act. And what is that Administrative Procedure Act? That Administrative Procedure Act allows John Q. Public to bring a claim against an administration, against an agency, a tort claim. This is what I did. I brought against the police department, the Department of Transport, and the DOT. I went back and showed they are agencies of the state. They are federally funded. And of course, the Attorney General went into the administrative court and says, Your Honor, Mr. Klaas is mistaken. They're not agencies of the state. They don't even work for the state. These people are purely private contractors working on their own. I came back to this. I object, Your Honor. Here is your North Carolina general statutes that clearly sit here to show that these are agencies. They are obtaining federal funding. And of course, the administrative court came back and says, we're going to dismiss it because this administrative court has no subject matter jurisdiction over non-agencies as these people are private contractors. They don't work for the state. They don't work here. Lights are on, but nobody's here. If you don't like our decision, take me to judicial review. So I did. I went to the second court. I brought a claim. The Attorney General Assistant was standing before the judge. Your Honor, Mr. Class brought an administrative claim against the Dallas Police Department in North Carolina and the DOT. And Your Honor, these are not agencies of the state. And the judge looked at him and says, yes, they are. They come under the governor's office. Mr. Class, what do you want? And I proceeded to explain what was going on. He says, I will give you my order. I said, okay, fine. 30 days went by, didn't hear nothing. 60 days went by, still didn't hear anything. 90 days went by, did not hear a word. 110 days, I filed paperwork back in and says, excuse me, pursuant to your local rules, as a judge, you had 90 days to file your order and to give me my order on this issue. He came back. I don't have time, and there's no such rule for me having to do it in 90 days, and I had more important things to do. I fired back pursuant to your local rules, and I told him what the rules were. I said, now, if you didn't answer me within 90 days, you have now prejudiced my case. Is there a possibility that you have been threatened by the state, that if you were to sit down and rule in my favor on this, the state would have to pay federal funding to me and go back and play the political subdivisions, their federal funding, all the way back to 1966 on that Highway Safety Act? Or is the fact that you yourself are guilty of these same charges? In order for you to rule in my favor, you'd have to find yourself guilty. Which one is it? He wrote me back and said, because you intimidated me, I can no longer sit on this case. I have to transfer this case to another judge. I got before Judge Ridgway. I had another Attorney General assistant. Mr. Class brought charges. I said, I object. As I proceeded to explain, the Attorney General and I got into a chess match, and the judge told the Attorney General, sit down and shut up. I don't want to hear another word out of you. Because this is what I'm saying. Know their rules. Know their language. Know their job. This is a chess game. You're matching wits, you're matching knowledge with these people. And of course, the judge came back in and said, Mr. Class, these are private contractors. I said, thank you. Let's talk private contract law. Does not these private contractors have to come in compliance with federal guidelines under Title 49? USC Code and CFR, and under Title 23 of the Highway Safety Act, under USC and CFR? Well, let me rephrase this, Mr. Class. They're a local government. Good that you and I talk local government, because pursuant to your North Carolina general statutes under local government, it sits here and says is that you have a hospital, you got a water department, you get this, that. I said, but you know what I did not find? I didn't see one thing. It says Department of Transportation. I did not see one thing about police department being part of the city municipalities. He says, excuse me, let me rephrase. After the third time, I walked with him and I cornered him again. He stopped because after his third chess move, I had him in checkmate for the third time. No matter how he tried to move his king, I checkmated him. Why? Because I knew their rules. I knew their language. I knew their job. The ruling I got is that they're private contractors and they don't work here. The lights are on, but nobody's home. I went after the sheriff department. I went after the police department. I went after the court system and the attorney general's office. I got a ruling back from the administrative court saying they don't work here. They're not part of the state. They're not agencies. I went after the state highway patrol, same thing. Went after the governor's office, same thing. Now, what does this mean, ladies and gentlemen? When they come back and tell you this, what does it mean? What it means simply is this, is that they are coming in and saying they don't work for the state, so therefore the state cannot be sued, but we will allow you to sue them in their private capacity. Have a nice day, go sue them. They'll bring a tort against them because the state is not taking any liability for their screw-ups. What this means. I did this on a federal level. I'm at DC. I got them to come back in and admit not part of the system. They are not here. Lights are on, but nobody's home. In my DC case, the appeals court hired a law firm not to go against me, but to back me against the system. Because my arguments that I put in were exposing their rule violation, their breach, their job description, and congressional intent, they could not get around. Ladies and gentlemen, this is important. Just because we're in the United States, from what I'm checking with some of the other countries, you guys have similar laws. You just have to learn what the administrative side is. You have to learn your Administrative Procedure Act. You have to go back in and learn what the rules of court are: local, civil, criminal, rules of evidence. What are they violating? What are they not doing? When you go down to the court and you get into your folder, is that folder empty? Is it? Is that folder empty? What should be in that folder should be a verified complaint. What should be in that folder is an affidavit. What should be in that folder is a summons or a warrant. Served on you and then picked up, not after the fact, before the fact. Did the prosecution pay for the case? Because if you go down and you file a claim, the clerk of court has their hand out. Right here, fill it. Put some money in it. Because if you don't put some money in it, we're not going to file your paperwork. Did the prosecution pay for it? Is there any proof that they paid for anything? These are all significant. These are all evidence of misconduct, of bad behavior. This is more proof of the fraud that's been being perpetrated upon you. Did your lawyer bring this up? Your Honor, if my client was to bring a case before this court, he would have to have paid, or he would have to fill out an informal papyrus affidavit that he is incapable of paying. And whereas the federal government has an unlimited source of finances off of my client, off of his birth certificate, and off of everybody else's birth certificate, I asked to move this court to dismiss it because the prosecution has not paid for this case. What we have here, Your Honor, is discrimination. If my client had to pay, then the government has to pay. And if the government is going to file under bankruptcy, and the government's coming in under informal papyrus, then they don't have a claim against my client. Is your lawyer bringing any of this stuff up? Is a lawyer talking to you about any of this? Ladies and gentlemen, your lawyer, the prosecutor, and the judge are all in cahoots with one another. This is all about racketeering. This is all about embezzling out of your account that has been set up through your birth certificate. And if you have a social security number, I'm not real sure how internationally how this thing works, but here in the United States, we do have birth certificates, we do have social security, which gives us a number for a routing number to the Federal Reserve banking system. This is the fraud that's being perpetrated. This is why these symbols in the back have merit once we understand how to use them. Once we learn the administrative side. And of course, they're going to come back in, well, you personally was not injured. Excuse me. That police officer was sitting on the street and he was stalking and he was obtaining federal funding because he's got a bulletproof vest on. He had federal funding because he had radar. He had federal funding because he has got a camera. He is obtaining federal funding under the Highway Safety Act. He is sitting here stalking in order to commit a crime, to stop somebody without any proper credentials, without any proper procedures. He doesn't have a complaint. He doesn't have an affidavit. He doesn't have a warrant, and he's in the process of kidnapping under armed, because he's carrying a gun. He's going to sexually assault this person because he is going to do a pat down. We're bringing charges because he didn't do his job right. This is a waste of taxpayers' money. Ladies and gentlemen, IRS is the same thing. Rod, you got to pay taxes. What are you paying taxes on, ladies and gentlemen? Well, I got Federal Reserve notes. That's exactly what you got, Federal Reserve notes. According to the speech here in the United States in 1933, 1932 on the floor of Congress, for some of you people internationally who don't know, Congressman McFadden addressed the Federal Reserve note as a mere promise to pay you someday. He flat out says it is not money. It is a promise to pay you. I have the congressional records from 1933, 1932. Mr. Lindbergh, Congressman Lindbergh, 1917, went after the Federal Reserve for impeachment, just like McFadden did 32 and 33. 1917, Lindbergh had a speech that shows at that time that the people of the United States was the credit line. That was his wording. The people are the credit line. We're the credit line. McFadden in 33 sit here and showed your signature is collateral. Your signature is the credit line. Not the gold, not the silver, not the house, not the car. Why am I having to pay tax when I have not received anything of value? I was given a credit line. I was given an IOU. Again, I want to bring up Title 18, Section 8, Obligation of the United States. Title 12, 95, 95A, 95B. We're under a state of emergency. We're under the bankruptcy. There's no money. How am I paying taxes under a bankruptcy whenever the system has stripped me of any means of being able to pay anything, and now you're hauling me into court for willful failure to pay what? With what? When I brought my claim against the tax department here in North Carolina, in the administrative court, we brought up the 1913 Federal Reserve Act. We brought up the 1933 Banking Emergency Act. And the Attorney General, Your Honor, Mr. Class brought up this 1913 Federal Reserve Act, and he brought up the bankruptcy of 1933, and I don't know what he's talking about. It's so unintelligible. It's frivolous, nonsensical. I object, Your Honor. And the moment this man gets done ranting, I'm going to sit here and we're going to have a conversation about this. Attorney General, sit down. I looked at him. I pulled out two $5 bills. I said, would you like to put on the record what these are, seeing how you don't seem to understand the 1913 Federal Reserve Act that created this? Would you like to put it on the record? And the judge told him, you shut your mouth and don't you say a word to him. I looked at the judge. I said, excuse me, would you like to sit here and put on the record what these are? He dropped his head and went. I said, wait a minute. You cannot tell me what these are, but you want me to pay taxes? And you cannot sit here and tell me what these are? How am I supposed to pay taxes if we can't talk about these? Ladies and gentlemen, know their rules, know their language, know their job. Understand what we're dealing with. Understand what we're talking about. Walk in with knowledge and understanding. You're playing chess with these people. It's up to you to sit down and be the best prepared to walk in to do checkmate. Every time they turn around, you want to do a checkmate on them. You don't want them to have anything available at this time for defense. No matter what they sit back and say, no matter what they want to bring up, no matter what they want to sit down and talk about, you have the ability to go head to head with these people. You have the ability through knowledge to walk in and smile and hand them their head on a platter. Just like they do you. You're using their rules, their regulations, you're using their guidelines, their procedures to confront them. And ladies and gentlemen, this is what I teach here in the United States. This is what I sit down and what AIB radio is all about. This is what this private attorney general show is going to be about, education. It's about knowledge. It's about your ability to be able to walk into these courts and win. And not walk in here and be sheared like sheep. The more knowledgeable you are, the best fight you put up, win, lose, or draw, is how well did you fight. I have had people that have used my paperwork, has walked in, told the judge, I stand on my paperwork. The judge just smiles, says, you stand on your paperwork while you're sitting 30 days in jail. Have a nice day. I've had other people walk in and they explained. In the moment they started rattling this stuff off, the judge shut the hearing down. The judge dismissed the case. Judge got him out of there. I went into court with my son-in-law. It's his ex-wife. I filed paperwork in. We walked into court, the attorney and his ex-wife never showed up. Judge called him up. Says, do you have an attorney? He said, my father-in-law's with me. His name's Mr. Class. Says, Mr. Class, do you have a North Carolina Bar Association license? I says, no, sir, but I do have credentials from the United States Congress that I do hold position as a private attorney general. You want to see my credentials stamped by Congress? And he says, well, we're not going to allow you to practice law today, but what we will do is we will postpone this and we will set this thing off to the side. He called Mark up. He says, Mark, I'm going to drop all the contempt charges against you, and we're going to dismiss this case. Now, if your wife wants to bring this up, ex-wife want to bring it up at a later date, then fine. If not, this case is dismissed. She could not get a law firm to come in because one of the things that we did on this is I went back and researched the Bar Association. The Bar Association in this country is either an agency to the state or a corporation to the state. And under their charter, they can only represent the state. You can only represent the state. Excuse me. I'm not the state. I'm a private individual. I'm not an employee. So how is this man coming in here representing me? That's why he never showed up. Only represent the state according to their charter. Go back and look up your bar association in your country. Find out what their charter says. Who can they represent? Don't say one thing about John Q. Public. How are they walking in here representing us, but we're not part of the system? That's part of the fraud. That's part of the scam that's been perpetrated. When my son-in-law went into other courts, the first thing the judge asked the opposing side, did he bring his father-in-law? He said, no. Then we'll hold hearing that had he had brought his father-in-law, we will postpone. We don't want him in here. I went into court with my daughter. We had a hearing. My daughter was found guilty. I looked at the judge and said, I will have you upon charges. And I did. The next time we walked into that courtroom, the judge left the courtroom. Why? The prosecution told my daughter, when your dad walks through the door, she's not allowed to be in here. He brought charges against her and she is barred from being in the courtroom. Your dad walks in. Knowledge, understanding, knowing their rules, knowing their job, knowing their language. Everything we talked about in here tonight, it all fell back into this category. Knowing their job, knowing their rules, knowing their language, knowing congressional intent. This is just an intro, ladies and gentlemen, of being a private attorney general for the United States. You all have the same ability. Check your laws. Find out what your tort claims are. Find out what your Administrative Procedure Act is. Do some research. You want to hold these people accountable? Knowledge. Like I said, in my DC case, the appeals court hired a law firm to back me up because I went back and proved so much fraud on the government side. They had no avenue. They had to come back in and support me in order to sue the government because I put such a case against them that they had no place to go. Think about it, ladies and gentlemen. Think about what we're getting into. Think about what you want. You're dealing with the courts. Do you want to be a victim? You want to be sheep? Or do you want to sit down and you want to be a ram? Do you want to be the one with the clippers and the shears? That is up to you. That choice is yours. Don't let them strip you of it. Don't let them take it away from you. Your knowledge and understanding, ladies and gentlemen, is where it sits. I have routed cages in North Carolina. I have routed cages in DCs. I have routed cages in a lot of federal courts around this country. And the reason why is because when they get my paperwork, they can't get around it. Why? Because it's their rules. It's their regulations. It's their verbiage, not mine, theirs. Shove their own rules. This goes right back into that Chineseman way back that developed what was known as the art of war. I live by that. Know your enemy. Know his restraints. Know his rules. Know his procedures. They can't change. They have set patterns. All you got to do is stay ahead of them. All right, ladies and gentlemen, we're down to the last couple of minutes of what we're getting ready to do. I hope tonight's program, with what we've done, was educational, because that's what this is all about, education. It's about standing up for your rights. It's about taking back our countries. It's about getting rid of the corruption that's sitting in here. It isn't the people of the countries that's creating the problem. It isn't us that's creating it. It's those that we put in office, those that we put into a trusted position. These are the ones that is creating the wars, creating the poverty. These are the ones that are taking away our livelihood and our rights. It isn't the American people. It's the idiots that's put in DC. And granted, we may have elected them in, but what they sit down and tell you what they do once they get in is two different things. Like I said, I hope tonight's been very educational for you and very knowledgeable. Take it for what it's worth. Go back and do your research. Get into your local law libraries. Get into your local court library. Get a hold of your local rules for your court. Get a hold of your civil rules. Get a hold of your criminal rules. Get a hold of your rules of evidence. If you want to know what these people's jobs, start going down into your cities and start getting into their city ordinances. What's their job? County ordinances. What's their job? Get into your state laws. What's their job? Federal. What's their job? Did Congress sit down and pass legislation to create these agencies? These are the things that you need to know in order to combat and to come after them and coming after you. I want to thank you for being in here tonight. And ladies and gentlemen, this is what it's about, being a private attorney general and being a bounty hunter. Our freedom is sitting right there. Thank you. Have a good night.
The pursuit of a free, fair, just, sustainable world should be the focus of every person on our planet. The reason it is not is because people are kept distracted by the illusions and deceit propagated by the corporately controlled mainstream media. In recent years, the rise in truly informed, savvy researchers and journalists who have all taken to the air in various capacities has given rise to a new genre of media. We have seen the explosion of truly free and independent media, and thus the need to create an ethical live broadcast network that facilitated these brave and tireless souls became apparent. With a great amount of research and meticulous planning, Conscious Consumer Network was created. CCN is a first-of-its-kind broadcast network that is specifically dedicated to free and independent media with absolutely no government control, corporate sponsorship, or advertising. The live broadcast network runs full-time with an average of 25 shows and live broadcasts a week. The high-definition live stream is free to view and is accessible from any computer terminal with online access, including laptops, tablets, smartphones, and smart TVs. All shows are archived onto YouTube and are freely available to view in order to educate and inform as many as we can without imposing monetary limitations. CCN was successfully launched on the 1st of January 2015 and has gone from strength to strength as we have improved and increased the capacities and functionalities of the network, as well as an ever-rotating and improving lineup of content which is broadcast daily. CCN is blessed to be the home of some of the hardest-hitting, most cutting-edge, truly educational and informative materials. Catch interviews, reviews, and talk shows from the many different and beautiful perspectives from CCN's family of interviewers and broadcasters. Since the 1st of January 2015, we have produced over 800 shows. We have over 2 million YouTube minutes watched every month, and we have an average of 1 million hits a day on CCN's website. CCN is viewed in over 147 different countries and hosts broadcasters from 5 different continents. The time has now come to generate funding to keep CCN on the air for the duration of 2016. The total sum needed to continue broadcasting for 2016 is $60,000. This budget includes the replacement of computer equipment, the acquisition of secure servers, which are most needed as we keep getting hacked, plus the renewal of the broadcast license fee for 2016. This is a fraction of the annual budget used by mainstream media networks producing a similar quantity of content. This is what makes CCN so successful, unique, and accessible, is the ability to run a project of this size and reach on such minimal resources. CCN does not claim ownership over any of the material we produce and broadcast, as we firmly believe that information is the common heritage of all beings, and thus CCN belongs to you, the public, and it is up to you all to keep CCN going. CCN would like to thank those who have contributed to the network in the past with resources, content, information, time, and energy. We thank you for supporting free and independent media.
Felt like the weight of the world was on my shoulder. Pressure to break or retreat